immigrationquestion.com, your go-to resource for U.S. immigration insights. We provide clear immigration news and information. Our platform provides a network of licensed attorneys who can answer your questions and guide you through the process. From visas to green cards, asylums to citizenships, immigrationquestion.com helps you to network with immigration attorneys so that you can move forward with confidence. Sign up today or download the app.
Hello, everyone, and welcome to today's live webinar brought to you by immigrationquestion.com, a network platform with meeting ground where individuals, employers, and licensed immigration attorneys come together to engage, learn, and exchange insights on immigration developments. My name is Ali, and I'll be your host for today's critical discussion, navigating H-1B layoffs, rights, next steps, and immigration options. So, across the US, layoffs in the tech and corporate sectors have left many H-1B professionals facing more than just career setbacks. They are also facing tight immigration deadlines and difficult legal choices, with just a 60 days grace period. Navigating the next step becomes a race against time. Questions about status, maintenance, transfers, and alternative visa options can quickly become very overwhelming. That's why this session is so important. Whether you've been recently laid off, are supporting affected employees, or want to understand the rules and options, today's discussion will help you make sense of the H-1B layoff landscape and plan your next move responsibly. We are joined today by Attorney Sophie Alcorn, founder and CEO of Alcorn Immigration Law. Attorney Alcorn works with tech founders, investors, and professionals navigating U.S. immigration pathways. A certified specialist in immigration and nationality law by the State Bar of California. And she brings a practical understanding of how immigration law interacts with workforce, realities, innovation, and global talent economy. You are welcome, Attorney Alcorn. Thank you so much for joining us today.
Hi, thank you so much to be here. Thank you for the opportunity, and thank you for providing useful information to so many people at a time when they really need it. I'm honored to be here, so thanks.
Thank you so much. So before we begin, a quick essential reminder, immigrationquestion.com is not a law firm and does not provide legal advice, guidance, or representation. This platform serves as a public meeting ground where individuals and organizations can learn about immigration topics, ask their immigration questions for free, and engage with licensed attorneys like our lovely attorney here, and to participate independently. To our viewers, it's about to get very interesting. Grab your writing pads and pens, and let's dive right in. So, Attorney Alcorn, let's start with the basics. When an H-1B employee is laid off, what are the immediate rights and obligations under current immigration regulations, and how much time do they legally have to take action?
Great question. So the first thing to always be aware of, whether you've been laid off or hopefully you're still maintaining your job, is to understand the difference between the expiration of the visa stamp in your passport, which is technically called a visa foil, but everybody talks about going for stamping interviews, and that's where they put the visa in your passport. So that has an expiration date. That could be different from the expiration date of your I-94, which you need to look up online after you enter the United States, because that governs how long you can be in the United States on this trip. And that's separate from your I-97 approval notice, which is the petition for your H-1B, your O-1, your L-1, and that says how long your petition is valid. So those dates might be inconsistent, or they might all be the same date, but whatever they are, you need to know each of them, because people should get a 60-day grace period if and when they're laid off, but they don't get it at the end of their petition. So one woman I spoke with yesterday got laid off at the end of a garden leave from her employer who had a severance package, and she was still being paid on this garden leave, and they never extended her H-1B But that meant that on the last day of her H-1B, she actually had 10 days to leave the country. She was not entitled to a 60-day grace period. So it's very important to know your dates carefully so that you can navigate this. But essentially, if you're laid off, assuming you have the 60-day grace period, which most people do, you need to either proactively change your status with USCIS on this trip so that you maintain valid status in the United States, or of course you can leave the United States by the 60th day. If you don't have money to pay for your plane ticket to leave, your employer is actually required to pay for your return airfare. So you can request that they pay for it for you. But if you do a change of status or transfer employment, then obviously there's no airfare for them to cover. So those are the primary things. You can also, of course, consult with an employment attorney to see if you have any other sort of rights for back pay or anything else that you might be owed, but that's separate from the immigration law context.
Thank you for that answer, ma'am. Next question. Many professionals are uncertain about the 60-day grace period after a layoff. How could you explain this period works in practice, and what options H-1B holders have during the window to maintain lawful status or transition to another visa category?
Yeah, that's a great follow-up question. So this is the scenario where you have the 60-day grace period, you want to stay in the United States, and you need another option, right? So the one option, there's always, if you have a good faith marriage, the 90-day fiance, marry an American strategy, not to be used lightly. Because there are very extreme checks to make sure it's a good faith relationship. So you absolutely must comply with that, but that would definitely save you in this situation. There's also the clean, smooth, stay in H-1B, get a new job, have the new company sponsor you. But the issue there is the job market, the timing of offers, and today, the government shutdown. So right now, even if a company was extending a valid offer of employment to you and they were totally on board with transferring your H-1B and their lawyers had already been paid and were ready to go and they were doing it, with the government shutdown, it's impossible to file a labor condition application with the Department of Labor, which is the first step to a valid H-1B petition. So there is new guidance on the USCIS H-1B website that says that the basically the government shutdown will be seen as an extreme circumstance that would excuse an issues, filing errors for somebody's H-1B. You'd have to work with your company's attorney to see if they're going to file the H-1B transfer without the LCA, or if they're going to wait till the LCA comes and then file a delayed H-1B transfer. Either one could potentially work based on this new USCIS guidance, but it is very difficult in today's circumstances to file an H-1B transfer within the 60-day grace period for all these reasons. And we did just get clarification too, that if you're transferring your H-1B to another company, you will not have to pay that $100,000 fee, which is an excellent piece of news to have that affirmation. But in order to have a backup option, the wise and prudent thing to do is to file a B1 or B2 change of status online with USCIS to request an additional 6 months of stay. That in and of itself might take 3, 6, 7, 8 months to get adjudicated, but you're allowed to be in the United States up until the final date while you're waiting for an answer. Some individuals choose to return to school on F1 status. They get an I-20 form after they've been admitted and they file a change of status online with USCIS. You can use premium processing for that to get an answer in 30 business days, which is quite convenient. And there are also other options, like we now file H-1Bs for people to work in specialty occupations in businesses they own. So it is possible, if you want to be an AI startup founder, if you have a company that has money in it, that has a job for you to do, that you could even transfer your own H-1B to your own startup now. And we've been doing that for a number of clients. They're routinely successful. We have to make sure we set it up in a very compliant, clear, structured way. But that's another option for people who are tired of being on this hamster wheel, and who wish they could pave their own course. And then obviously the O1 visa is another great option for people who qualify. So there's a variety of options for how to navigate the post 60-day visa option transfer.
Oh, thank you for that. And I hope you guys took note of that. And the following question is for those considering a job transfer, as attorney said, or a change of employer. What are the key compliance and documentation steps they should prioritize to avoid gaps in the translation?
Okay, so step one is you got to get the offer letter in place. Step two, the employer or petitioner needs to have an immigration attorney onboarded to initiate your transfer or change of status. Step three, they're going to ask you to provide all of your immigration documents, your past immigration history, anything demonstrating maintenance of status from your most recent date of entry into the United States to the present. That includes the biographic page of your passport, your most recent and probably any and all visa foils in your passport, your I-94 that we mentioned, your US I-94 travel history. They might also want to see any I-20s or DS 2019s from any F1 or J1 status, any past work permits, so EADs from J2 or I-485 pending or H-4 EAD that you might have had in the past. And most recently, if you were in a work status such as H-1B or STEM OPT, then you would need to show 3 recent pay stubs to demonstrate maintenance of status as well. And then depending on the visa category, there may be additional evidence of your degree, your transcripts, or education evaluation. Those documents might need translations. You may need proof of a job abroad or evidence of extraordinary ability. So there could be a lot of things, but having all of that ready, organized, clearly labeled in a online cloud storage folder will really help the future attorneys working on your case to streamline everything for you.
Got that. And final question, attorney. In cases where finding a new sponsor quickly isn't possible, what are some practical backup strategies? For example, changes of status, dependent visas, or temporary departures that can help preserve future immigration eligibility.
Yeah, so we talked about the change of status to F1. There's also the option, if you're married to an H-1B holder, of going on to an H-4 dependent spousal visa. Now, whether you can apply for a work permit or not depends on which milestones of the employment-based green card process your H-1B holder spouse has met. So you might or might not be eligible for a work permit. It's often best to time an H-4 change of status and EAD with your spouse's extension or amendment. And if the company won't pay for premium processing for the H-1B, you and your family can. But normally tying the H-4 EAD to an H-1B for your spouse will help it get more of a priority processing because there's no premium processing for H-4 or EAD. Sometimes people do depart the country, apply for a visa stamp, and come back in to do that. The important thing to know today is you must go to your country of citizenship or country of residence for visa stamping. So you're no longer allowed to do third country national processing in another country. So that's very important for visa stamping right now. Sometimes people do go abroad and wait for a job offer and wait for their H-1B transfer to come through, and then they re-enter on an existing valid H-1B visa. That's an option as well. And then also just, when reemployment isn't immediate, we do help a lot of founders and entrepreneurs transfer their H-1Bs to their own startups, and that's becoming more and more viable of an option. We've had a tremendous success rate this year for that, and we've helped many, many people get that peace of mind knowing that the risk they're taking is a business risk only. It's not a employment/immigration risk on top of the job that they're doing. So immigration's hard enough, and having that entrepreneurial founder H-1B option is really great because it helps you, decouple your life from an employer. And that provides a lot of peace of mind, security, and freedom to individuals currently navigating this volatile immigration landscape.
Okay. Thank you for that, attorney. And I really do hope everybody like took a pen, wrote it down. I hope it helped you. So to everyone joining us live on Facebook, YouTube, LinkedIn, and other platforms, thank you for being part of this essential conversation. Whether you're an H-1B professional navigating uncertainty or an employer seeking clarity, this discussion is about awareness, preparation, and informed decision making. Suppose this is your first time joining us. Welcome. ImmigrationQuestion.com is a networking platform where immigrants, families, and employers can ask immigration related questions for free and engage directly with licensed immigration attorneys. You can participate in any language, and many users may also qualify for a free confidential consultation. We are also proud to share that ImmigrationQuestion.com is now a BBB accredited, a recognition of our ongoing commitment to transparency, accountability, and service to immigrant and business communities across the United States. Attorney Alcorn, as an immigration attorney with extensive experience working with tech founders, investors, and professionals navigating the U.S. immigration pathways, what are your thoughts on how the platform like ImmigrationQuestion.com is helping immigrants and attorneys network effectively?
Oh, I think that any opportunity to get more information, especially when things are changing so fast, is such a valuable resource. So thank you for making this available to people around the world. And thank you so much for the invitation to participate today. I really appreciate it.
We really do love having you, Attorney Alcorn, and thank you for that perspective. Before we move into our live Q&A, I would like to speak to this for employers managing layoffs involving H-1B workers. What are the best practices should they follow to remain compliant with the Department of Labor and the USCIS requirements while they are supporting effective employees' responsibility? What's your take on this, attorney?
Yeah, if you're a company and unfortunately you have to go through a layoff of your employees, and if some of them are on H-1B, it's very important to consult with your immigration counsel before issuing the layoffs. This is because it's going to affect different team members in different ways. And, often people are really sad when this happens. It's not anybody's first choice. And there are a lot of things that you can do to help manage this path as compassionately as possible, such as providing immigration consultations for your affected team members so that they know their grace period options and their options to stay in the US longer. And of course, the employer is not responsible for any of those future immigration options, but it can show, dedicated professionals who have given a lot to the company that you appreciate what they've done. But also critically, there are several visa types that do require mandatory reporting to USCIS once employment has ended, if it's before the final date of the petition. So employers have liability to report those layoffs to USCIS, and that's something that your immigration counsel will help you with as well. We can certainly support companies in doing that. So definitely, if there's going to be a layoff, reach out to immigration counsel to make sure that you're handling all the withdrawals properly, as well as providing comprehensive immigration consultations for your affected team members.
Thank you for that, attorney. So, if you are just joining us, we've been in an insightful conversation with Attorney Sophie Alcorn on navigating H-1B layoffs, rights, next steps, and immigration options. We are now moving into our live Q&A session. This is your chance to ask your own questions directly to a licensed immigration attorney. Drop your questions in the chat or call us live at 516 703 3483. That's 516-703-3483. And we'll get to as many as we can. Okay, so first question. Angelisa. They've started firing people from my job. I am on an H-1B visa and I'm scared I can be next. Please, how many days will I have before I must leave the US?
Hmm. Thank you for that question. I'm so sorry to hear that. So, first of all, Anjali, you need to look at your visa and your passport, your I-94 expiration date, and your I-797 approval notice to see the end date on your petition. You need to see how much time you would normally have to stay in the United States on this trip. If your company terminates you before the final date of your authorized stay on this visit, then you would have the 60-day grace period to find a new job, leave the country, or change your status. But because the job market's, a little bit tricky right now and there's a government shutdown, you need to probably file a change of status to B1, B2 as a backup, or look at filing a change of status to F1 as a backup. But please keep in mind, of course, the information I provide is just like our host has mentioned, it's educational only. This is not legal advice because I don't actually know anything about your situation. But in general, if there's time left on your petition, you should have the 60-day grace period available to you.
Okay, I hope that helps, Angela. Now, the next question from Matthew. What other visa or status options do I have if I cannot get a new H-1B sponsor within the grace period?
Great, all the ones we've been chatting about. So you can leave the country, you can do a change of status to F1 if you get admitted to school and you get an I-20. You can do a change of status to B1, B2 to request 6 months. You can transfer your H-1B to a new company. If you're qualified, you can file a change of status to an O-1 visa. If you're an entrepreneur and you have a company with ability to pay, then you could transfer your H-1B to your own company for part-time or full-time. So there are a variety of options available to you.
Okay, thank you. And next is Ben. If I already applied for a green card and I got laid off, will it cancel my process?
Probably not, but it depends on which stage of the green card process you made it to. If PERM has not been certified yet, then you will lose the process. If an I-140 has been approved in the EB1, EB2, or EB3 categories, then you will retain a priority date, which is a spot in line for a green card. You'll have to restart another employment-based green card process later. However, you will still have an advantage on the visa bulletin because your priority date will help you advance to further up in the line in a future green card process. And then the third milestone to reach would be if your I-485 adjustment of status has been pending for at least 180 days, then you could consider becoming eligible for something called AC-21 portability, which allows you to transfer your green card to a same or similar occupation at another company without restarting. So those are the three critical milestones to keep in mind.
And I hope you took note, Ben. And next is, we still have questions. I think we're good. They have filtered it off. So we're good. And thank you so much, Attorney Sophie Alcorn, for sharing your insight on this critical topic. Your explanation on how to handle status changes, explore alternative visas, and plan proactively has provided much needed clarity for workers navigating this uncertain moment. And to everyone watching, thank you for joining us. Remember, understanding your rights and acting within your legal time frame can make every difference, like Attorney Sophie just said a while ago. You can always visit immigrationquestion.com to ask your immigration questions for free and engage directly with licensed attorneys. Many users may also qualify for a free confidential consultation. If you'd like to revisit today's discussion or share it with someone who might benefit, in that case, the full replay will soon be available on Spotify. Search Borderless Talk by immigrationquestion.com. Join us again on Friday for another timely and in-depth discussion on immigration trends and workforce challenges that are shaping the America's future. Once again, Thank you so much, Attorney Alcorn. I hope we helped a lot of people today. And thank you to everyone watching. Until next time, stay informed, stay proactive, and stay connected. That's it for me. Again, this is Ali and our lovely attorney, Miss Sophie Alcorn.
Thank you, Alyssa. Thanks for having me. Thanks, everybody.
Have a good day.